Good morning. Thanks very much for joining today's webinar on property misdescription and consumer protection. I'm Linda Story and I'm a partner and head of the home ownership group here at PMC and also head of our sector group. Now today's session is going to be focusing on the consumer protection from unfair trading regulations, which just for ease, because it's such a long title, I'm going to refer throughout as the CPRs. Now, the CPRs are the main piece of legislation that controls business to consumer advertising. And it's key for anybody dealing in the sale of property in whatever aspect. Now, the regulations were originally introduced as part of our membership with the EU, and now the UK has left the EU, the regulations remain as part of EU retained law. Now, please do put, as we go through the session, please do put your questions into the Q&A and not the chat, and then we'll pick those up at the end. Obviously, slides will be available after today. So on the slide there, you'll see obviously a list of general prohibition, misleading actions and omissions, aggressive practices, ban practices. These are the core provisions of the CPRs, which we are going to have a look at. And then at the end, we're also going to have a look at the offences, how it works, and use of disclaimers. Obviously, an effective use of disclaimers is important. Okay, so without further ado, let's have a look at the overview of the CPRs. So as I mentioned originally, the CPRs apply business to consumer practices. Okay, so they're designed to ensure fair trading with consumers, originally across the whole of Europe, but obviously the rules will obviously diverge as time goes on between us and Europe. And the rules that we see apply in 4 categories. So first of all, there's a general duty to trade fairly, which we'll have a look at. There are misleading actions and omissions, aggressive practices, and practices which are banned in all circumstances. And if we look at the next, so here, those first 3 categories are principle-based. So there is a breach if they have the effect on what has been done or has not been done, makes a consumer make a different transactional decision. Okay, and we're going to look at the detail of that. The final category, that Schedule 1 of banned practices, it absolutely does not matter what the effect has been on the consumer. They will always be unfair. And it's really important to remember that the consumer, for the purposes of the CPRs, is not just your existing customer, not just the purchaser in front of you, but prospective customers, prospective purchasers. And the commercial practices similarly as wide. So it covers the whole lifetime of any activity that you deal with, from advertisements to pre-agreement advice and complaints. And complaints handling procedures will be part of the CPRs and will be assessed accordingly. So a really key part of what needs to be addressed. And who's the consumer? Well, it's anybody acting outside their usual trade or business. And obviously, for the purposes of purchasers, they are not, it's not their usual course of business. And so, of course, they will all be consumers to you. Okay, so the CPRs prohibit unfair business to consumer to commercial practices in all business sectors. So if any of you have looked at the CPRs, they cover all industries. So from car sales to whatever, double glazing, etc. And the CPRs and the property aspect is just one kind of bit that we are obviously looking at today. And the CPRs apply irrespective of the location of your business, so you can't advertise remotely from elsewhere in the world and hope to obviously escape the provisions of the CPRs. And they apply wherever the marketing or services are capable of reaching consumers in the UK. And we'll see when we come to look at the general duty, that the duties are quite wide to capture unfair practices, although, and again, we're going to discuss it later, there are discussions about a possible widening, possible changes to the CPRs. Okay, so when we're looking at these categories of 1 to 3, where in order for there to be a breach, we need to make an average consumer make a different transactional decision. I think we need to look at that in a bit more detail. So, as I say, it affects the average consumer making a different transactional decision. Now, as there I've put on the slide, a transactional decision is really widely defined. It can be a decision to view a property, a decision to book the survey, a decision to pay a reservation fee, etc., etc. Every act of that process in buying a property is a transactional decision. And the average consumer, now we're going to have is someone who's, quote, reasonably well informed and reasonably observant. What does that mean? Well, we're going to have a little look in a minute about what that means in a bit more detail. The important thing to remember is the test is the average consumer, not the consumer necessarily in front of you. So if the consumer you have is either particularly relaxed or not, as the case may be, that does not matter. The test is what would the average consumer do. And I put there on the bottom, the average consumer is taken to be reasonably well informed, reasonably observant and circumspect. And so let's have a look at the next slide so we can see a little bit more detail about what does that mean for you when you're delivering services to prospective purchasers and so on. So the average consumer is expected to pay some attention to documentation, but not necessarily to read everything, not to necessarily understand small print, but they are expected to pick up the key points. They're expected to make known their own particular requirements. So, for example, I want a parking space is an obvious one, or they have an existing pet and they would like consent for that. They're expected to view the property, if obviously that's possible, and to take note of what they see. They're expected to make their own inquiries about publicly available facts and take those on board, but note, as you are the professional, if you tell them something different, then it is assumed that the average consumer will rely on the advice from you rather than that publicly available information. They're expected to ask questions of the things they don't understand, but generally to trust you. You're the professional, your teams are the professionals delivering the service, and so they will trust you in what they say. Okay, so when we look at the average consumer, the CPRs drill down a bit more to that. So there isn't an average consumer for every group of person. There is an average consumer for the type of consumer that person is. And the CPRs specifically provide what they class as vulnerable groups. And those vulnerable groups are the elderly, first-time buyers, obviously due to their inexperience, students, disabled. They are essentially the majority of your customers. They are classed as a vulnerable group. And most associations are really geared up to dealing with this anyway. You have lots of information to support purchasers in understanding what they're buying and so on. But it's really important to know that that's a higher standard to address that vulnerability is really important to match. So as we've seen, the CPRs is average consumer, average targeted consumer, and average vulnerable consumer. And so when you're targeting, obviously, a scheme for first-time buyers, is the average first-time buyer that you're targeting and that you need to address. Okay. Now, if we remember, there were these 4 prongs, and one of the prongs was this general prohibition, this general duty of being fair. And this general prohibition, the idea is that it will be able to shift over time. And the idea of this is that it's judged against the standards. So, for example, the provisions of the Capital Funding Act, the provisions of the general industry practice. So it's an objective standard against which you are judged. And just as the Capital Funding Guide and the GLA advice shifts and changes each year, so will that standard, that professional diligence standard. And this is, as I say, very much considered the catch-all. Okay, so that's the general prohibition. Now, misleading actions was the one of the other prongs that we saw. And a misleading action is something, obviously, that is done that contains false information or in some way deceives or is likely to deceive the average customer. And for those of you who remember way back when, before 2008, and this when the CPRs came in, when we had the Property Misdescriptions Act of 1991, this misleading actions was in essence the Property Misdescriptions Act, where misdescriptions about the characteristics of a property, is it 1 bedroom and then it turns out it's got 2, or vice versa, the origin of a property, misleading photographs, etc. Here I've put on the slide there, saying you're going to be bound by a code of practice, and you display that, and obviously that's not the case. All these things were in the Property Misdescriptions Act, as was then. So that's misleading. Actually, I think they're fairly self-explanatory. Now, misleading submissions were something before 2008 that wasn't, interestingly, a breach, but obviously now is a breach under the CPRs. And it's a breach to omit information, if omitting that information would make the average consumer make a different decision. And I think as I put down there on the 3rd bullet, supplying information too late can also constitute an omission. And I think that's really important. So this can particularly apply when you're issuing complaints procedures and so on and so forth. If a consumer doesn't know where to go to, then clearly they may raise a complaint. The idea, of course, of key information documents now is to bring forward that timing of information. But yes, it's not supplying it at all is not just the breach, it's also doing it too late. Okay. So continuing on the theme of misleading informations, it's important to remember that the omission of information is not everything that a purchaser wants, but rather what the consumer wants, but rather everything the consumer needs to make the decision. So obviously I've just put there, obviously a tenant might want to know the lowest rental sum that a landlord would accept, but that's not material information. The material information about whether they want to rent the property is what's included, what is the rent, what facilities are there, and so on and so forth. So it's not everything that obviously needs to be disclosed. Okay. Now, actions and omissions, I was thinking it's quite nice to look at some examples and see those in a sort of property context. So a serious problem about the title. Now, this isn't where, particularly in new builds, where you've cured title defects by insurance policies and it's rectified. This is something that could be a showstopper. And I think you would absolutely need to disclose that, because that could affect, obviously, any purchaser's ability to obtain a mortgage. Structural defects, obviously more not necessarily on a resale, but has there been ongoing subsidence or other structural issues? Japanese knotweed is a common one. Again, because this will affect a buyer's mortgage, it may affect who they can apply to, depending on the location of the Japanese knotweed. It's really important that a purchaser is aware of this. And obviously, some of these things you absolutely are not going in the advert for the property, but they're things that would be discussed with a purchaser, things that you might discuss with the broker in advance if there was a serious problem and closed Japanese knotweed, for example. And I've put there the new build warranty. And here, again, this isn't disclosure about what I would call a normal new build warranty, an HBC and so on, but more if there were an unusual warranty cover, so just a structural engineer's certificate. Something, again, has a big impact on whether a purchaser is going to be able to obtain the mortgage that they hope to get. Non-standard features, leases of solar panels. Leases of solar panels are now obviously incredibly rare, but coming up on the left side, leases of ground heat source is becoming more common and will become more common. And so again, that's something that needs to be discussed if that's applicable. Any rights of way that affect a property. And again, I know I keep mentioning about complaints procedure, but you know, it is something that can get forgotten as a element of CPRs. And with lettings, I put there on the bottom, generally in lettings, the majority of omissions or actions that cause problems is fees, unfortunately, and they absolutely need to be disclosed as to what needs to be paid and when. Okay. Now, aggressive practices, if you remember, this was that other prong, aggressive practices, and here we have is a breach to adopt commercial practice that intimidate or exploit. Sounds obvious, I'm sure. And a practice is aggressive, is likely to significantly impair an average consumer's choice. Now, I've put there, obviously, it's good practice and can really be helpful for purchasers to have lists of recommended purchaser solicitors where they can access services. Absolutely nothing wrong with that. But obviously, to force a purchaser to choose a particular firm would clearly not be appropriate and could potentially be a breach. So now, in the context of lettings, obvious things like entering the property and refusing to leave until payment is made. And I've put there at the bottom, pressurising a buyer to act quickly. And this isn't what I would call normal chasing for deadlines, for exchange and completion, and have you organised your mortgage and all the normal appropriate action. This is asking buyers to skip processes of which are appropriate for them to do, forcing them, not that we've ever known anyone in the sector to do it, but asking exchange without searches and so on and so forth. So this is out of the ordinary aggressive practices. Okay. Now the ban practices, so although all of those others, the actions, the omissions, the aggressive practices, they're all judged on that average consumer making a different decision. The ban practices, it doesn't matter. We don't need to see the effect on the average consumer because it is no longer relevant. And I've just put there's a list, and I've just put 3 there. Faking credentials, so you display a code logo and it's not there. Bait and switch, so luring a customer with an attractive advert with one price and one product, and you actually have no intention of selling them that. You intend to sell something else. And limited offers, which are false. Now, it's interesting that ban practices there have been discussions recently about extending that list of ban practices. And it'll be interesting to see what happens over time because obviously rules never stand still. And one of the elements that's been discussed as a possible extension is false consumer reviews. It's very much considered that with the internet and so on and so forth, this list of banned practices could possibly do with an extension. But I think that's one to sort of look out and watch for, and as time goes on. Now, the redress and offences, action can be civil or criminal enforcement. And it's really important to recognise that in a property context, just as much as any other, there will be action, an alternative action, in many different routes. So if a purchaser has already exchanged, then clearly there's going to be their sale contract in place. Is there a separate action for misrepresentation or replies to inquiries and so on? So it's the CPRs is just one route. And I've just put that on the slide because before 2014, before the amendments in 2014, consumers had no right to take any claim themselves under the CPRs. And when we get to the next slide, we'll see how who can take action. But they had no direct right to take anything, and now they do. And that was considered an important element, so that they have some control if an action is taken. But it is intended to be for that exceptional. So it's intended to be where the misleading action or aggressive practice is a significant factor, and where they have entered into a contract after, as I put there on the slide, after 2014. So it's very much there for that exception, and I've put there on the slide, enables consumer to possibly undo the contract, have a discount, or seek damages. And I think these rights of direct action by consumers are probably less likely in the property context, and really much more so for other consumer activity. Okay. So how does action take place? Well, essentially, it's trading standards, and they enforce the regulations. And the Competition and Markets Authority, the CMA, also has powers to tackle breaches through regulations. Now, trading standards enforce the regulations using both criminal and civil courts. And I've put there the time limit for bringing a prosecution is 3 years from the date of the offence or 1 year from discovery. And this does stop a purchaser. And during some recessions, we do see an increased rise of potential complaints from purchasers, where they might say, well, I've looked back and the brochure said that it was going to be a door and then it was a window, but they've been in occupation for some time. And it does stop that latent bringing up of claims. And the defences are due diligence, that you did all you could, innocent publication. You send something to publishers, and by error it gets published. So it is that. Now it's also important to remember that trading standards don't have to, as we sort of go to the next slide, they don't have to take action. They have a choice whether to take action or not. And consideration when they take action is always given at the time whether or not there are other means, other what they call established means to take action. And the Advertising Standards Authority is a really key route. And I don't know if you saw recently that the Advertising Standards Authority actually made a change and ruled as inappropriate a recent advert for shared ownership campaign. So it isn't always where there's a breach that action comes under the CPRs. They may consider, trading standards may consider that actually it's not appropriate to take action in that way, and then pass it, as I say, to the Advertising Standards Authority. Now, good practice is if we look at sort of a little bit more detail where some things pop up from time to time. And I think resales can be a tricky area for some associations to be able to address. because there's a lot of variation about whether associations view the property that's being resold. They have less control, less information about the property because, of course, somebody is already in occupation. And I think for resales, it's really, really important to tie up that information that comes from sellers and from leaseholders, and that they really understand the importance of the commitment that they have to make sure that the information that they give you and the information that is advertised is correct and accurate and up to date. And I've just put there on the slide, at the beginning, obtaining a commitment from sellers that one, that they've checked it all, two, they understand the importance of it, and three, they will tell you if it changes. Really, really important. And I put there, some obvious things about internal processes, training, obviously that's part of today. Keeping material up to date is really, really important. If an advert is dated, it's really clear if when something was stated. And I put there, ensuring information is given in good time. As we mentioned, and I mentioned earlier, information delay can be a breach of the CPRs. Okay. Now, in a new build context, some physical things in show homes can be potentials for problems. Sometimes smaller furniture is used. Sometimes doors are removed, and those physical things, there's nothing necessarily wrong with them, doesn't necessarily cause a breach. But what's really important is that any prospective purchasers, when they're viewing, are alerted to those things, because it's easier for a purchaser viewing and not even to notice that a door has been removed, make an assumption about how they might organise a room, only to find that that's not even possible when the door is back on. So those physical things are really, really important. And also, as we move on to looking at sales off plan, again, those depictions, artist impressions, really, really important to control, particularly where there are changes in the site, and models, structures, and so on and so forth are all continuing statements on which purchasers can potentially rely. And I've put there about, colours of tiles, exterior paintwork, and so on. And actually, the courts over time have been very generally understanding that in a new build environment, things do change. And in fact, for a potential purchaser to be successful for changes of roof tiles, the changes must be significant. And that's because, hand in hand with what purchasers enter into, there's a lot of information on a new build sort of scenario about the colours might change, and discussing changes because of the supply network. So if it gives you comfort, the courts are there sort of saying, actually, the changes need to be significant for there to be a breach for changes on new build. Okay. Now, disclaimers. I think disclaimers are an important thing to look at, because they have a really key role in the part of any advert. And I've put there, using a photograph of an existing similar property to advertise an unfinished property. That's not a problem. But obviously it needs to be clear when somebody is looking at that photograph that photograph is not of the development, it's of another similar development. And I've put there in the second bullet point the judge of a disclaimer. And the rules are, to be effective, a disclaimer needs to be as bold and compelling as the statement to which it relates. Now, that doesn't mean that you can't have a generalised disclaimer, and obviously all adverts will have generalised disclaimers, but there is a risk that without other disclaimers along the way, that reliance on one standalone general disclaimer is unwise. And normally, and I've put on the next couple of slides some examples of disclaimers whereby they go alongside the advert. So you have the page about perhaps the layout of the site, and against it you have that disclaimer there at the bottom about the tenure changing. You might have landscaping, and again a disclaimer next to it where you have the layout of the plans. You might have the disclaimer about size of rooms and so on and so forth. So it's, and I've just put a few more on the next slide. As I say, marketing names, postal addresses can't be relied on, windows and so on. And so I think it's really important with disclaimers that they are used, but as I say, used wisely is better. And there we are. So I think that's a scanter across, and because I like to give everybody the positivity of finishing a webinar early. We've got plenty of time, hopefully, for some questions. I don't know if there are any in the chat. Let's just have a look. So I think we have one question here where somebody has, they've messaged in, they've said they've got a situation where there's no Japanese knotweed on the property being sold, but they are aware that Japanese knotweed is next door. Should that be disclosed, bearing in mind that the property being sold is unaffected? And I would have said, albeit it's a difficult call, I think if you were disclosing it, I think it would be a breach not to mention that Japanese knotweed were next door. Yes, it can be doing, obviously tempered by saying that it hasn't affected the property being sold. But I really do think that not to disclose something next door, would be unwise. And then someone else has just dropped in. We'll do one more question about how the CPRs work with the key information documents. Obviously, all of the information in the key information documents are continuing statements and need to be correct. And it's really just part of that information that purchasers will rely on. So I do hope that you found this morning's session useful. The slides absolutely will be distributed. Hopefully you have my contact details. Any queries, questions, just let me know and drop me a quick line. And thank you very much. And hope you all have a good rest of the day. Thank you very much.